Well, hello everyone. I'm your immigration attorney, Jorge Molina, and it's a pleasure to be talking to you today, October 21st, 2021, about this topic that we started talking about a few weeks ago, which is inadmissibility and how it affects your ability to enter the United States or to adjust your status in the United States. So last time we were talking about what admissibility was. We saw that inadmissibility was pretty much a finding that a person cannot be allowed into the United States or cannot adjust, meaning pretty much changing your status from either no immigration status to lawful permanent resident, or from any other immigration status to lawful permanent resident, or in some other cases, changing your status from one category to another. So let's think of like students to workers, things of that nature. But in essence, so if you're inadmissible, you can't do those things. You can't adjust your status. You can't enter the United States. On occasions, there's waivers. There's other exceptions, and we saw a list of things that would render you inadmissible. Right. So we saw some health-related grounds. We saw some criminal-related grounds, and we also saw some immigration violations grounds. So today we're going to go into greater detail as to and talk to you about some examples of what would make you inadmissible. So we're going to talk about first crimes involving moral turpitude, which is these are the quintessential criminal activity that makes someone inadmissible. And second, which is equally as important and as common, is drug offenses. And third, we're going to talk about misrepresentations. And in that context, we're going to talk about misrepresenting your immigration status versus falsely claiming to be a United States citizen. All right, so that's what we're doing today. If you're interested in knowing a little bit more about inadmissibility, you can check out our previous recordings and our articles and our website, or, be on the lookout for our next webinar, which is also going to be on inadmissibility. But so, last time we talked about, criminal activity that will render you inadmissible. So one of the largest categories are crimes involving moral turpitude. For short, we call it CIMTs, right? So, so what is a CIMT? So, in essence, a CIMT is any offense that is considered base, vile, or depraved, and is not accepted by society. In essence, anything that we know that inherently it's a bad act, right? So think of things like theft, kidnapping, where there's fraud involved, right? Where there's some form of trickery, or doing something that we know that it's inherently bad, like killing someone, right? That's a traditional CIMT. But not everything is about murder or something so nefarious or evil like that. On occasions, we're humans, we make mistakes, and we do things like, for example, shoplifting. Or, for whatever reason, we, falsify a document, that could land us in serious trouble, regardless of the reasons, right? So if it's either to feed your family or just a greedy person trying to enrich themselves. But to wholly illustrate this point on CIMTs, I want to take one particular crime in the state of Texas, and that is forgery of a financial instrument. So this falls within that fraud category, right? So all fraud cases require some mental state, right? You must have the intent to trick someone, right? So by either trick or misrepresent some fact for your gain, right? There's different categories of fraud. Sometimes you can just lie about one detail on in an insurance application. Well, that's not as severe as falsifying a check, for example, right? So there's different ranges of punishment. In our case, forgery of a financial instrument, the range is 180 days in state jail to 2 years. Okay, so this is considered a state state jail felony. So why are we talking about the ranges and stuff? So let's say you commit an offense like shoplifting, right? Or not you, someone you know, and they take it, they hide it, right? And maybe it's a item of clothing or a toy or perfume, whatever it is, right? And then they're caught. Well, the likely in Texas, the range of penalty for that is between 180 days to 365. For immigration law, that is incredibly important, because even if you commit a crime involving moral turpitude, a CIMT, even if you commit that, if the maximum potential penalty is 1 year or less, and that person is sentenced to less than 6 months jail, it will fall within the petty offense exception, meaning that it's not considered an inadmissibility ground. So here, let's say you're caught, or someone gets caught shoplifting. They get convicted. It ends up being a Class B misdemeanor, which carries a maximum sentence of 180 days in the state. So by definition, that would fall within the petty offense exception, and is not a ground of inadmissibility, even if you committed the fact that even it's something debased and depraved and something unacceptable in society, right? It will fall within the petty offense exception. But now compare that to our example, forgery of a financial instrument. So the range of conduct of potential penalty is 180 days to 2 years. So by definition, because the maximum amount of time that you could be sentenced for that is 2 years, it doesn't fall within the petty offense exception. So even if you forge a check for $5 or less than that, it would make you inadmissible, and it wouldn't fall within the petty offense exception. That is because the state punishes that conduct, the fact that you're falsifying a financial instrument. It could be a check, it could be a money order, it could be a cashier's check, it could be anything, any medium of exchange like that. The state punishes that and considers that conduct particularly bad, right? So that's why they're making a state jail felony. So it doesn't fall within the petty offense exception. So what do you have left? If you made a mistake, or someone made a mistake, well, in some cases, you would be eligible for a waiver. So before you submit anything to immigration, or before you plea, or they tell you this is a good deal because you're not going to go to jail, you won't do probation, you're just going to plead guilty, and this is going to stay in your record. Right? No, you really need to consider or reconsider that offer, especially if you haven't, become a lawful resident of the United States or a U.S. citizen. So before you take that deal, or before you file anything on immigration, now you have that issue, consult a qualified immigration attorney. And we'll see if you qualify for a waiver, or if it would be a good idea for you to file anything with immigration. Okay, so that's the first example. That's a CIMT. That's a typical CIMT. Here's another typical case that we see often, and it relates to controlled substance. All right, so big picture for controlled substances, any offense that you have would render you inadmissible. It would make you inadmissible. You can't, enter the United States. You can't adjust your status. Nothing like that. However, there's an exception. If you have an offense, or someone, has a drug offense in their record, there's an exception if it was for possession of 30 grams of marijuana or less, and anything relating to that. Now, the example that I'm going to give here to illustrate this point as to how wide of a net it is to be inadmissible for a controlled substance offense, I'm going to use possession, not of marijuana, but of drug paraphernalia. So for those not familiar, you can be charged with possession of drug paraphernalia if you have an instrument or something that you're using to consume marijuana. So it could be a pipe, it could be it could be paper, it could be a bong, it could be anything that you're using. It could be a can, it could be an apple. Anything that the police catches you with to use marijuana could lead to a charge for possession of drug paraphernalia. So what happens? All right, so people think, okay, well, I'm not convicted of an offense dealing or an offense for controlled substances. It's paraphernalia. That doesn't matter for immigration law purposes. If the offense is related to a drug offense, then you're inadmissible. It doesn't have to be. It doesn't even have to be a particular drug. It's just any drug listed under the Controlled Substance Act would render you inadmissible. And then it's up to you to show those related to 30 grams of marijuana or less, or otherwise you're not eligible for a waiver. So let's look at the example of drug paraphernalia and see how it usually comes up. All right. So let's say, you got your friend Jack, right? And your friend Jack is a student, had a little marijuana, and stressed out, decided to go smoke some weed in a nearby park. As he's done smoking, police officer comes by, he smells something, investigates, and he finds her friend Jack there. Jack freaks out. The police officer detains him, pats him down, scolds him. I know what you're doing, and I see your pipe here and your lighter. And then, Jack is very sorry and saying, well, I'm very sorry, I was doing this. And the man is transparent about it. Officer is pretty reasonable, understands he's a student. So, you know what, I'm not going to arrest you, but I will give you a citation for drug paraphernalia, right? So they cannot arrest them or give him a citation for possession because there's no more marijuana, right? But they're giving him a citation for drug paraphernalia. So here, Jack, doesn't do it again. He's very sorry about this. That happened, when he first arrived to the States. He promptly pays that ticket, and then after a few years, someone tells him, hey, you know what, you can get that erased from your record. It's not going to be in your record anymore. And then Jack goes to a criminal defense attorney who expunges the record. And then when you expunge the record in this state, it's illegal to reproduce that record again. Actually, it can land you in trouble, especially if you're a government officer. So, after a while, Jack does very well in school. He gets a great offer to start working for a company who's going to sponsor him, file for a green card and everything. And then he wants to do adjustment of status. Well, what's the issue? Well, the issue here is that he's inadmissible because he has a conviction, even if it's just a ticket, for an offense related to a controlled substance. All right, so, that's his biggest problem, right? So now goes to you and say, hey, what should I do? Well, you should tell him, go talk to an immigration attorney. You should talk to Jorge. So what would we do? Well, so first off, if he hasn't gotten his record expunged, I would say don't get it expunged until you become a lawful resident of the United States, because you're going to have to give them your full record so you can show that you're eligible for this waiver, right? So because you need to show that it relates to an offense of possession of marijuana of under 30 grams, right? But if there's no record, how are you going to do that? So, in many cases, we do get creative. We try and get as much information as possible. Often, police officers cooperate. They help out. On other occasions, the attorney representing the person can write a letter and explain that, well, I was very sorry, didn't really understand the immigration consequences here, but we did do this work for him and it did relate to this. But it's up to the applicant, to the person wanting to get a waiver, to qualify for it and to show that they do qualify for a waiver on those grounds, and that's relating to less than 30 grams of marijuana. But, something that seems so simple as a ticket for not even possession of drugs, but of drug paraphernalia can, ruin your plans. So before you plea out, before you do anything, when you have those type of issues, consult a qualified immigration attorney who would do a full analysis for you. But, in many cases, we need to break it to people. It doesn't matter if it's just drug paraphernalia. It was relating to a controlled substance. Therefore, you're inadmissible and you have this issue. Okay, so another common problem that we see, which leads to our third point on inadmissibility for today, are people who falsely claim to be United States citizens. Now, the way that the law is written for this inadmissibility ground says that you are inadmissible for a false claim to citizenship if you ever falsely claim to be a U.S. citizen for any purpose. So it could be, to try and enter the United States, or it could be applying for a job, could be applying for a scholarship, applying for a school, for any purpose. And to any person, doesn't even have to be a government officer. It could be a potential employer, or a school, or, a bank. You're applying for a loan or whatever it is. So, and the sad thing is that it's considered a death penalty for immigration purposes. There's no waivers available. So, even if it was 20 years ago, well, even if it was before April 1st, 1997, before then, you could apply for a waiver. Difficult, but after that date, there's no waiver available. So, even if it was 20 years ago, you're still inadmissible, and there's no waiver available, and it's very severe, and it breaks my heart having to explain it to people because it's so severe, right? And they could have, I have so many children in the United States, I've done so much, I pay so much in taxes, it doesn't matter, there's no waiver, very sorry. But compare that to falsely claiming to be a lawful permanent resident for employment purposes. So instead of filling in 9-9 saying that you're a U.S. citizen, you fill 1 saying that you're a lawful resident, and it would not lead to the same immigration consequences. First, even if you do misrepresent that you're a lawful permanent resident, there's a waiver available if you're married to a U.S. citizen, or you are or your parent is a United States citizen or lawful permanent resident. And same thing with spouses, right? So if there's U.S. citizens or lawful permanent residents. But the other interesting difference here is that it's limited to false representations for to federal officers for an immigration benefit. So either coming into the United States or in immigration applications and stuff like that. So it's much more limited. It's not as severe, and there's a waiver available. But folks, if you have a doubt on this matter, if I said this in such and such application, or I don't know what I did, consult with an attorney before you submit anything, because this will prevent you either, spending a lot of money that you're not going to get back, or making mistakes that could cost you dearly. Okay, folks. So again, it's a pleasure talking to you about these topics. I hope you find it helpful. And, if you have any questions, you can always reach us at 469-708-5800. Again, 469-708-5800. Or send us an email at info@jmolinalawfirm.com. Again, my name is Jorge Molina. It's been a pleasure talking to you today. Have a great day.